9-0, the unanimous victory at the U.S. Supreme Court in favor of President Trump. There were two parties to this case, President Trump and the Colorado Republican Party. We represented the ACLJ, the Colorado Republican Party.
Justice Roberts writes, in the opinion, all 9 members of the court agree with the result. Justice Barrett writes in her concurring opinion, all 9 justices agree on the outcome of this case. That is a message Americans should take home. Then the 3 concurring justices, which also agreed with the opinion, Sotomayor, Kagan, and Jackson, said to allow Colorado to take a presidential candidate off the ballot under Section 3 would imperil the framers' visions of a federal government directly responsible to the people. So I want to send a message to the naysayers about the institutional credibility of the Supreme Court, to those that have talked negative about the Supreme Court of the United States or have said it's become a political partisan institution. There were pundits this morning saying this is going to fall down to some kind of political lines, Republican nominees and Democratic nominees. None of that happened. On a case of great magnitude, this is a tremendous victory, by the way. Not just a victory for President Trump, but a victory for our electoral process. I would say it's the most significant case like this that we've ever handled. And to have all 9 justices issue what is called a per curiam opinion, that means the court is speaking.
You saw the timing it took for the Supreme Court to put together what was a very short opinion. I mean, I was expecting, because they were taking so much time, like hundreds of pages, but it was very tightly worded, very specifically worded.
All the justices were speaking with one voice, and the one voice that they spoke with is because the Constitution makes Congress, rather than the states responsible for enforcing Section 3 against federal office holders and candidates, we reverse. In other words, the states can't do this. So I think to the contrary, I know some pundits are saying that, but Andy, in reality, the fact that it's per curiam sends a more powerful signal.
It's put together by the input of all the justices, and I think it gives it added impetus and added influence and added persuasiveness in that no one justice has spoken and the court was not divided.
What's the big takeaway? What do you see as the big takeaway here?
The unanimity of the court. That impresses me. I'm looking at the concurring opinion of Justices Sotomayor, Kagan, and Jackson, the 3 liberal members of the court. And here's what she said. Sotomayor, in writing, said, allowing Colorado to make the decision as to who to keep on the ballot for the presidential election would create a chaotic state-by-state patchwork at odds with our nation's federalism principles.
Yep.
That is enough to resolve this case.
And the chaos, CC, is something we pointed out to in our briefing, both at the petition stage and at the merit stage.
Even the liberal justices focused on the chaos, as Andy just pointed out, that you get, a single candidate would be declared ineligible in some states, but not others. And that just would cause complete chaos and actually nullify the votes of millions of people. It could have that effect.
And the fact that it is unanimous, what's your takeaway on that part?
It removes basically instability within the system. It's important to keep in mind that individuals in Texas and West Virginia have proposed either legislation or judicial action to remove President Biden from the ballot on the other side.
This is the paperwork, and it's actually 3 times this, because this last volume, which is about an inch thick, there are 4 of. I just can't hold them all. This is what we filed in this case to get this victory. This is the amount of legal work that went in.
This case was bigger than Donald Trump's interests. This had to do with the party's ability to nominate the candidate they thought best to represent them on the general election ballot. If they can do it to someone like Donald Trump, then they could certainly do it to other candidates in the future. And that was something that we wanted to avoid. And thank God that this ruling did just that.
Let me quote Justice Sotomayor, Kagan, and Jackson. They wrote a concurring opinion. They agree with the result. They wrote a concurring opinion. To allow Colorado to take a presidential candidate off the ballot under Section 3 would imperil the framers' vision of a federal government directly responsible to the people.
Commentators say this is a win for Trump, but it's actually a win for our constitutional
100%.
Republic. Because we, the voters, and whether you vote Republican or Democrat, we are the winners, that we actually get to vote for the candidate of our choice, and that a state cannot decide that. And, they, in this opinion, they point out that even historically, when you look at the history, states have never enforced the 3rd section of the 14th Amendment against federal candidates. So it follows the Constitution. This is a good opinion.
States have no power under the Constitution to enforce Section 3 with respect to federal offices, especially the presidency. That is on page 6 of the opinion. How much clearer could you be? Here's what we wrote in our brief on page 13. Congress, and only Congress, has the authority to enforce Section 3. States cannot claim for themselves authority to seek disqualification of presidential candidates absent congressional authorization. What the court said, states have no power under the Constitution to enforce Section 3. We said Congress, and only Congress has the authority. That's where the briefs become so critical to these decisions. Let me go to the next thing we wrote in our brief, and we'll put it up on the screen. It says, it is Congress that has long given effect to Section 3 with respect to would-be or existing federal office holders shortly after ratifying the amendment Congress enacted what they called the Enforcement Act of 1870. That's in the opinion. Then in our brief, look at this. Shortly after Griffin's case was decided, Congress enacted the Enforcement Act of 1870, directed specifically at Section 3. And then it says Enforcement Act of 1870, our merits brief at page 21. So that's why the briefing is so critical in these cases. The oral argument's the fun part, but the briefing is where you win and lose cases.
One of the heartening things is when you write a brief, as we have written a brief, and the Supreme Court basically quotes you verbatim or takes you and at your word and trusts you enough to know that you have interpreted the law and advocated the law to them in a fashion that they basically copy what you say. That's a good thing to do, and that's one of the things that we have been able to show that we did consistently in this case.
As you have been pointing out, Jay, the arguments that we made in our brief were basically followed almost verbatim in the Supreme Court opinion and even by the liberal justices. Yep. We pointed out the chaos argument, and they point that out as well. So our attorneys did an excellent job.
I think the chaos issue, Harry, really got to the court. They knew that the wrong decision here would create state-by-state chaos.
Even though that wasn't really argued that much by the attorneys, the Supreme Court was aware of this. But it's also important to keep in mind that the Democrats have basically staked their claim to power on the notion of chaos. They say, accept our understanding, our interpretation of the Constitution, or else. And I think the Supreme Court, both left and right, withstood the arguments of the Democrats, and that is in part due to the arguments that the ACLJ has made in its briefing.
I make the joke, and it's not a joke, is when you've lost the case below, which we did. I mean, the Colorado Supreme Court ruled against us. You want it to say, as Cece just said, somewhere in the opinion it says reversed. And it says in the very last sentence of the opinion, as she said, the judgment of the Colorado Supreme Court is reversed, and the mandate shall issue forthwith. So let's talk about what the mandate is.
Mandate is the actual order from the Supreme Court of the United States to the Colorado Supreme Court, saying essentially in plain English, this is our decision, now do what we say.
I want to quote Justice Barrett because I think this is a good way to get ready to end this broadcast. All 9 justices agree on the outcome of this case. Let me say that again. All 9 justices agree with the outcome of this case. That is the message Americans should take home. But that does not happen without the support of friends like you supporting the work of the ACLJ.